Pretrial custody has now been brought here into the courtroom. Also here before the court is Mr. Brian Potter. He is the agent from the Michigan Department of Corrections, who has prepared today's pre-sentence investigation report. And again, we are here for sentencing. This involves a single conviction for a home invasion, 3rd degree. Mr. Carnes, any amendments, corrections, or objections to make to the contents of the pre-sentence investigation report?
No, Your Honor.
Mr. Harrison, same question.
I don't have any proposed changes.
Thank you. Mr. Harrison, allocution, sir.
I know that there's a lot that I need to say,
What?
in all honesty.
You always say a lot.
Sorry,
There's
a couple of things going on here that mitigate against that.
Miss McNamara, you're not here in the courtroom very often. If you were, you'd know what I meant. Don't worry about it. All right, thank you.
It's a 0 to 3 guideline. She served. This is 88 days. I'm not sure that count is accurate. We thought it was going to be 90 days, but that's well beyond the point. I think it's putting far too fine a point on it. There is some logic that would have you put her on probation as recommended for a year, but she would be eligible for half-time release. I'm a little bit leery of that in terms of the recommendation. I understand she's had some conversations with Mr. Potter that I think he and she have a plan for her to be successful on probation. If that's true, I trust both of them. I trust Ms. McNamara and I trust Mr. Potter, if that's the determination that they've mutually reached. I also see that she had some difficulty on bond, so I can't emphasize enough that her main objective, as well as it should be, is to get out of jail. Now, if that means that you leave it at the 88 days served and put her on a short-term of probation, I think that's a workable solution for her at this juncture in her life. The thing that needs to happen here is Mindy needs to get her act together, and she knows that. I try not to be too critical of her because I think I've gotten to know her a little bit. She's a strong, independent, resilient woman. And I think if she channels that energy appropriately, there's nothing she can't achieve. And I think the problem is in the past is that she's been unable to focus that. And maybe through the interaction of the MDOC and Mr. Potter, that can be achieved at this point and put all of this silliness behind her. Thank you.
Thank you, Your Honor. I noted in the PSI, the defendant claims that she's had no issues with drugs except for marijuana, which she quit in 2014. However, I recall in the district court, the defense making a motion for release to treatment, which is much more consistent with what I read between the lines of the police report, what I hear when I was talking to witnesses preparing for the prelim, and what I've heard from the defendant's ex-boyfriend when I was prosecuting him for domestic violence, and that is she has a massive problem with methamphetamines. I would ask the court for time served and 24 months probation with random drug testing. I agree with a lot of what Mr. Harrison said. My impression of Ms. McNamara is that she's smart, strong-willed. Unfortunately, she has, let me back up, this isn't unfortunate. Fortunately, she has not much criminal history at this point, and I sincerely hope she continues to live a life with not much criminal history. I think a period of probation would help ensure that. Lastly, there is requested restitution here of $1,770. I did review the.
It also says leave it open, so I don't know what that.
I think it hasn't been agreed to. I would say in the PSI, we do have sworn testimony from the victim saying $1,520 in cash, plus a phone, plus a laser pointer, plus they baseball memorabilia, gold coins were all stolen. I think that $1,770 figure is reasonable based on that sworn testimony, but I'm also happy to conduct a restitution hearing.
Mr. Harrison, on that point?
It would obviously be our preference to have a restitution hearing. If they want to leave it open, that's appropriate, I believe.
All right. Ms. McNamara, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say today?
There's not, Your Honor.
All right. All right. There we go. Court looks at the defendant's prior criminal history. There are several things that that are not scored based upon a 10-year gap. The court, however, does recognize that the defendant does have a prior criminal history and involves several things that give the court concern. We have some crimes of dishonesty, such as retail fraud, also operating without insurance, without plates. The court takes a look at those and says, and driving license suspended. That makes a question of supervisability, because the person fails to comply and thinks they can get away with stuff, they're going to go ahead and do it. That's of a concern. However, the court uses that as only a reason for basis for reasonable grounds to give any period of jail, plus also the bond violations. Now, I will make a statement here so Mr. Harrison and Mr. Hartel can hear it. Maybe the court has been pretty flexible on allowing bond modifications and treatment. If you don't put a list of what they're suffering from, I will not sign it. Okay, because then what you all do is you tend to ask for the release to treatment way so often, which of course treatment's better than sitting in jail. But then we've got questions about, well, what do they really need treatment for? So do not ever submit to me another request or stipulation to modify bond and send somebody to a treatment program unless you detail very specifically what substances and abuse issues they have. I will reject it and your client will stay in jail. So because I've noticed this and the district court judges have noticed it, there's a little bit of an over sense of entitlement and laziness in these requests to modify bond. So in this particular file though, the defendant's set a guideline range is only 90 days. And she's already served 88 days of credit. The court therefore places the defendant on a period of probation for, and I'm just going to go 12 months. The court adopts the terms or conditions that are listed on CFJ 145 pages 2 and 3. Actually, no, it's only on page 2. It's a pretty short probation recommendation. Court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee, supervision fees of $30 a month or $60 a month if there's any electronic monitoring, and there should have been a DNA fee.
Yes, Your Honor.
$60 DNA fee payable to the Wexford County Sheriff Department. The court will leave restitution open for the next 30 days, and you all need to get on top of that. As for a jail sentence, excuse me, The court sentences the defendant to the 88 days with 88 days of credit. Have I missed anything, Mr.?
88 days to 60 months.
I'm sorry?
88 days to 60 months, is that what?
60 months, yeah, because of the,
Thank you,
the-
Mr.
yeah, thank you.
First one.
I missed anything else, Mr. Potter?
No, you're.
Anything else, Mr. Harrison?
No.
And Mr. Connors?
Your Honor, I would ask the court to add a condition of random drug testing, which is not currently listed on page 2 of CFJ 145.
You know, I was looking at that. I don't see it listed on there. There's not anything for treatment. But I'm told she doesn't have any problems, even though she can't show up for drug testing. So, but I will put on there drug testing because I don't believe it. I believe that there's some kind of lack of complete picture being painted here. So she's not to use or possess any illegal or controlled substances, which includes recreational marijuana. She'll be subject to random testing. I'm not going to have her sent to any rehab because according to what the defense is saying, she hasn't had a problem in 11 years and doesn't have a problem with anything else, even though she can't show up for testing. So I'm not going to place her in rehab, and you're going to test her. If she pops hot, it's no longer well, I actually know it still would be a technical. Yeah. Anyways, all right, thank you very much. The court's providing to Mr. Harrison, Ms. McNamara, 2 copies of one document. This is your advice of your appellate rights. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you complete the bottom half of the copy that you're taking with you and return to court within 42 days. Again, place your initials on the one copy, neither lacks nor waives any rights. You have the right to be considered for early release from your probationary period at halftime if you've been compliant with all the terms or conditions. Also, all fines and costs are due within 56 days, over 20% penalty can be added. However, if you make all the payments during the end of your, by the end of your probationary period, the court will waive the 20% penalty.
Okay,
Any questions?
thank you, Your Honor.
Thank you. We're adjourned.
No problem. May I approach you?